the people of Zambia, do hereby solemnly adopt and give to ourselves this constitution. So says the preamble of the Republican Constitution. But over a month since the Constitution Bill was signed into law, debate has continued on various clauses in the amended Constitution, implying that the new law is not only a blessing, but may be an inconvenience to others. With a good number of perceived or real gaps, or indeed lacunas in the supreme law of the land, one question arises. Did the nation go to sleep during the constitution-making process? Sunday interview today features the chief advisor to the government on legal matters, the Attorney General, Likando Kalaluka. Sir, welcome to the program.
Thank you very much. Good evening, and good evening, viewers.
Your office is relatively a quiet one, and you were appointed to the office slightly almost a year ago.
Yeah, April last year.
Last year, yes. So you haven't yet even clocked a year. Very little is known about you. Who's Likando Kalaluka?
Well, thank you very much. I was born on 26th April, 1977. I was born here in Lusaka. For primary school, I was at Mkandawira Primary School, then later on went to Regiment Primary School. Ultimately, I went to Kablonga Boys for my secondary school from grade 8 to 12. Then I went to the University of Zambia, where I studied law. Towards the end of my studies, that is in the third year, I was actually one of the Students' Union leaders, and I was the treasurer of a Students' Union. And unfortunately, I was suspended for 1 year. But it wasn't me only. I think government then had made a decision, or was it the university management, had made a decision to suspend the entire student union leadership, allegedly because they said we were inciting students to riot, which we actually didn't do. But then, that is all in the past now. I was suspended for 1 year. I came back, graduated in 2001. I went to Ziale in 2002. So I graduated in 2002, went to Ziale in 2001, and then ultimately was called to went to Ziale in 2003, and was called to the bar in 2004. Yeah, and then thereafter, I've been involved in the affairs of the Law Association of Zambia. I think I'm one of those few lawyers who at 2 or 3 years practice, I was elected on the Council of the Law Association of Zambia. I've been on the Council of the Law Association of Zambia, I think from only 2 years into practice, up to about the time I was appointed Attorney General, when by that time I was the Honorary Secretary of the Law Association of Zambia. Of course, sometime in 2011, I had to go for a master's in Ireland, and then I worked briefly in the UK for about a few months, and then finally came back. Otherwise, I've been in private practice all along with the firm of Ellis & Co.
Now, I did introduce you as chief advisor to the government on legal matters. Maybe you could shed a bit more light on exactly what your duties are, briefly.
Yeah, like you have mentioned, I'm the chief legal advisor, meaning that I advise government on just about everything, actually. And then over and above that, any contracts to which government has an interest in, by government having an interest in, I think we mean for instance, if it's a contract being entered to within any of the ministries, and then we've got all these parastatals like ZESCO, RDA, the local authorities, all these companies where government have shares. So if any of these have to enter into any contract, which has financial implications, they all have to bring the documents to me so that I can approve as to the legal content and to ensure that the interests of the state are not compromised by that agreement. And then, of course, I sit in cabinet. I'm part of cabinet, so I offer advice there. And then, again, if any person is commencing any litigation against the state, against any organ of the state, that is the central government, or is it the judiciary, again, I represent the state. But of course, I can't be in court in all matters. So I've got a team of lawyers who actually go to court on my behalf. In some instances, I actually attend court. But actually, I have that oversight on all the litigation cases. Yeah.
Relatively young, relatively new at the bar. There was some criticism that probably the position or the boots of Attorney General were too big for you?
No, I don't think so. In fact, when you look at the olden days, you'll find that people occupying such high positions like the one I have were actually relatively younger. I did speak to some state councils who were Solicitor General and Attorney General. In olden days, some of them actually attained this position when they were much younger than I was. But again, in terms of actual discharging of my duties, I think I've been equal to the task, and I can't say that it has been too big for me. No.
Let's get to the actual topic that we're dealing with today, the Constitution. As it stands now, it's over a month since the document was signed into law by the President. We still have so many debates and various interpretations. Does this mean your office did not do a good job in ensuring we had a good document?
Well, I don't think it's a question of my office not having done a good job. You recall, if you look at the constitutional history, for some time now there's been an element of criticisms to the successive governments where it was mentioned that whenever people come up with what they want to be in the Constitution, the government would maybe put aside that and then put whatever they want into the Constitution. So this time around, the President had directed that we should actually implement the Constitution as it is. We should put it into place as it is. Of course, there were one or two clauses which were changed that relating to provincial assemblies, where it was believed that those were maybe it was going to be a huge cost on the Treasury. So the idea basically was to put in the Constitution as was recommended mostly. So that was the actual position. And then also the rumblings, what you're saying, people criticizing and so on and so forth. I think mostly the criticism arises from maybe failure to fully appreciate its contents. I think fairly, the drafters came up with a very good document, reasonably. But of course, there is need for further actions or steps being taken to make it more operational. For instance, if you go through the Constitution as amended, on several instances, it says that this will come into place as will be prescribed by an act of parliament. So what this means is that most of the provisions are not actually effective. They're not actually operational until there's an act of parliament which will prescribe the processes and so on and so forth.
So we'll have a constitution that really doesn't really come into effect immediately per se, because people have to wait for this act and parliament is on recess. And if they don't deal with it in the coming sitting, it means we do not really have some certain provisions catered for until parliament sits again after August 11th.
Not really. The constitution is operational. I'm talking about some of the clauses which people are taking issue with. Some of them are a result of maybe they are not being an act of parliament. Substantially, the constitution is in place. And then, fortunately, there is one little document which people always forget. This is Constitution of Zambia Act number 1 of 2016. This is the act which actually provides for the transitional elements. So most people just look at the constitution as the amended constitution, and they forget to look at this small document, which actually provides for what should happen to facilitate the implementation of this actual amended constitution.
So probably that act, that hasn't been publicized as much as the actual document, the constitution.
Yeah, maybe not. But if you look at the key provisions of this document, you'll find that most of the controversy which people are having, they are easily answered by Act number 1, because the main issue is that people don't know what happens. For instance, if I may, there's an issue of a constitutional court. People are saying, is the constitutional court in place, and so on and so forth. If you look at Section 21 of the Constitution of Zambia Act, that is Act number 1 of 2016, the amended constitution is Act number 2. So Act number 1 of 2016 says that subject to Section 6, where an act of parliament is required to give effect to an article of the constitution as amended, that article shall come into effect upon the publication of the act of parliament or such other date as may be prescribed or under the act of parliament. In other words, the amended constitution, as we have it, with respect to the Constitutional Court, maybe I can look at clause 120, sorry, Article 120. Article 120, which talks about the system of courts, it says the following shall be prescribed. First it talks about the courts, then it says the following shall be prescribed. The processes and procedures of the court. So when the Constitution is saying the following shall be prescribed, what it's basically saying is that there shall be an act of parliament which will state the processes and the procedures. So effectively, if there is no act of parliament, it means that we will not have the processes and procedures.
Which means the court doesn't come into effect.
Yes.
But again, there's so many issues that are being referred to.
Just a bit. But then we have the Supreme Court, we have the High Court, we have the Subordinate Court. With these ones, we have acts of parliament already in place. So all these are already operational. But for the Constitutional Court and the Court of Appeal, we don't have an act of parliament which prescribes the processes. So effectively, they are not yet fully operational.
But the Constitution says they're into effect, and so many issues have been referred to the Constitutional Court. For now, it says this shall be adjudicated upon by the Constitutional Court.
Yes.
So what do people do? Where do they go? Because
so, for instance, the courts, the Constitutional Court is maybe the hallmark of this Constitution. It's something which was not there until the 5th of January when the President assented to the Constitution. Yeah, so previously there have always been courts which have always been sufficient. So should there be anything which will require, maybe, which would have required the Constitutional Court to be dealt with, it will be dealt with by the High Court or by the Constitutional Court, by the Supreme Court. But as of now, since the Constitutional Court is not in place, you have to use the High Court or the Supreme Court.
Other legal minds have argued that, as it stands, the Supreme Court does not have judicial standing because there's the Court of Appeal, and matters are supposed to be referred to the Supreme Court after the Court of Appeal.
That's what I'm saying.
So now they cannot adjudicate any issues coming from the High Court because the Constitution says it's from the Court of Appeal.
Yeah, that's what I'm saying, that the issue of the Court of Appeal and the Constitutional Court, I've just read the relevant provisions. I've read Section 21 of the Act number 1, which states that where an act of parliament is required before an article can become operational, then that article will only become operational upon the publication of the act. And then I've also gone to Article 120, Article 120 of the Constitution as amended, which states that the processes and procedures of the courts will be as prescribed. So since there's no prescription yet, prescription is done by an act of parliament, surely to argue that the Constitutional Court is in place, it's neither here nor there. But then, if one has, for instance, right now, judgments are coming out in the High Court, and appeals are being processed in the High Court. So the Court of Appeal will only come into place upon us having an act which will state all the processes and procedures to be adopted in that. If right now someone files an application for argument's sake, in the Court of Appeal, which procedure are they going to use?
In this case, people should ignore the statement in the current Constitution which says the previous clauses have been repealed and replaced.
No, that's what I'm saying. There is Act number 1. Act number 1 says...
Which overrides the other?
It says that where there is anything which is supposed to be done under the Constitution as amended and has not yet been done, then what was prevailing will continue in place.
How long will it take for this Constitutional Court and Court of Appeal to be in place?
Yeah, I think
these seem to be very key institutions that, as you said, are the hallmark of the new Constitution, and they're not in place.
Yeah, what we've been doing, actually, we've been working round the clock. That is both the judiciary, we've been working in collaboration with my office, and then also the Judicial Service Commission, to ensure that with respect to the judiciary, soon we'll be coming up with a bill, which we hope will be introduced into Parliament as they sit next week or so. So the bill will be drafted, and then, of course, it has to go to Cabinet for approval, and then finally taken to Parliament. So sooner or later, soon and very soon, we'll have a bill in Parliament, and then actually, hopefully, the act will be passed, which will now operationalize both the Constitutional Court and the Court of Appeal. Similarly, in the same vein, the Judicial Service Commission has been actually working round the clock also, trying to look at who should be appointed as judges to man these courts. We hope that, all in all, hopefully, I don't know how Parliament, the schedule will be, but by maybe mid-February or at the most late February, everything will be in place.
So the assurance is that before the pause, before the elections, the Constitutional Court will be in place.
Oh, yes.
Court of Appeal.
Definitely, I think those ones will all be put in place.
Now, let's look at, I want you to speak to the Article 7, the position of judge-made laws in light of Article 7 of the amended Constitution. I want you to highlight that article.
Yes, please. Article 7 sets out what constitutes the law in Zambia. And it says that the law in Zambia consists of this Constitution, the laws enacted by Parliament, statutory instruments, Zambian customary law which is consistent with this Constitution, the laws and statutes which apply or extend to Zambia as prescribed. Of course, it leaves out judge-made laws or precedents.
Precedents, yes.
Yeah, so I've heard in some quarters it has been said that judge-made laws, by virtue of this, is no longer
acceptable,
part of a law. But then when you go to Article 25, Article 25 of the Constitution states that the Supreme Court is bound by its decision except in the interest of justice and development of jurisprudence. What it simply says is that the Supreme Court is bound by its earlier decision, meaning that a decision which a judge made earlier on shall bind the Supreme Court. And by that, by implication, it means that the judge-made law or the precedent which was made by the earlier Supreme Court will apply, will guide the court right now. So effectively, it means that judge-made law will apply, because this Constitution doesn't even say that only those decisions of the Supreme Court which were made after the Constitution will apply. It just says by its decisions, meaning that if it made a decision in 1964, if a Supreme Court made a decision maybe in 1980, for argument's sake, that decision will bind the Supreme Court today.
It remains as a precedent under the books.
Yes, it remains as a precedent. So effectively, notwithstanding the fact that judge-made laws are not mentioned in Article 7, in terms of everyday practice, in terms of what will be happening in court, a decision which was made by the Supreme Court earlier will play a role, except, of course, like what was stated, where there is to develop the law, because the law can't be static. In some instances, the Supreme Court would say, well, yes, we had said this earlier, but due to developments in socio-economic developments and also the developments in international law, maybe the Supreme Court will move further from the earlier position. But the bottom line is that that position of the Supreme Court will still apply. So one can safely go to court relying on a decision which a Supreme Court had made and then hope that the same decision will be implemented.
Now, I want you to look at controversy, the issue of appointment of deputy ministers. The current constitution is silent on the position of deputy ministers. Why was this huge lacuna allowed to go through?
I don't know whether it's a lacuna. Because when you look at the draft constitution, I think it was publicized and put in circulation. It didn't provide for deputy ministers. So it was a deliberate decision where maybe, or I'd like to think that as Zambians, we decided that maybe deputy ministers are, yes, an expense. Maybe we should reduce the number of people who are deputy ministers. I think, I presume that was a decision, but it wasn't a lacuna. It was a
decision by the people
yes.
to remove the position of deputy minister.
Yes.
So what is the way forward?
That's the way forward. Unless, of course, if the people again want to bring them in, then well and good. Again, there's an argument, or maybe again that one is in court. But again, there's this Act number 1. It provides guidance it provides guidance in terms of what to be the transitional position. So
what you're saying clearly is that the position of deputy ministers has been scrapped.
Yes, going forward. It's not there in the Constitution as amended.
After August 11th, there'll be no deputy ministers.
Maybe, in fact, maybe by operation of the law, because the Constitution says, Act number 1 says that the Vice President, ministers, deputy ministers will continue in office until the President terminates the appointment, and by implication of the law, until Parliament is dissolved. So maybe that is, Parliament will have to be dissolved sometime in May. So when Parliament is dissolved, then there will be no ministers and deputy ministers inclusive.
So how can this be addressed in case people want the deputy ministers back?
Well, that can call for an amendment. In fact, like I had mentioned, this is the first time we're having such an elaborate constitution after the amendments. Mostly our experts had gone around the country to get views that traveled outside the country. We have borrowed from what's obtaining in South Africa, in Kenya. But again, it then necessarily follows that whatever you have gotten from Kenya will have to apply and should be good for Zambia, for instance. So over time, possibly after the elections, people would be able to propose amendments. In fact, the beauty about this constitution now says that an individual can petition Parliament to come up with a law or to do an amendment. So if the people would decide that deputy ministers are required, I'm sure an amendment will be effected.
The people or the politicians, most probably in this case?
I believe the politicians are representatives of the people. And I mean, they're elected by the people. So I think the idea of detaching politicians from the people is not exactly entirely correct. The same principle arose, or at least the same question arose when we're talking about the mode of adoption of the Constitution. When you look at what was in issue, mostly I've stated that the draft, as was prepared, was mostly enacted into law. The main issue, which we have always wanted, was the content. There's an issue of the content, and there's an issue of the process of achieving it. Now, if we believe that the content is what people want, then for some time now, from 1991. So now we have got all these provisions. And then people are still saying that, no, this is not a people-driven constitution. So a people-driven constitution only come into place through a referendum. And then people have also gone ahead to say that this document is illegal, whatever that means, which I find strange personally, because the process by which this amendment to the Constitution was done is clearly sanctioned.
By law.
By law. On the other hand, the process of subjecting everything to a referendum, well, there's no law which specifically states so. Of course, there's Article 79. It says that if you want to amend
the Bill of Rights,
then you can use a referendum. But the same Article 79 says that to amend any other provision of the Constitution, you have to go to Parliament. So I don't know how that can be called an illegal document. And then it also shows that maybe people just want to...
People are arguing probably based on promises that were given to them. Anyway, I want to look at the issue of MPs. It's also a controversial one. We've seen, I don't want to mention cases because probably they're in court, where people have said they will not vacate their seats because the Constitution permits them to stay on.
Well, maybe I can go through Article 72, the relevant portion of which states, that's Article 72, 2, subclause 2. It says the office of a member of parliament becomes vacant if the member resigns by notice in writing to the speaker. So that one is clear. If a member of parliament resigns by notice to the speaker, the seat will become vacant. The other one is if a member becomes, that is under B, a member becomes disqualified for election in accordance with Article 70. You can go to Article 70, states out, for instance, if someone has been, it's later discovered that he's bankrupt, or maybe he has been in prison for one of those are the reasons which are stated under Article 70. C states that acts contrary to a prescribed code of conduct. D resigns from a political party which sponsored the member for election to the National Assembly. Again, there it's clear. If someone resigns from a political party which sponsored that person, then the Constitution says that the seat is vacant. E is expelled from a political party which sponsored the member for election to the National Assembly. F ceases to be a citizen. G, having been elected to the National Assembly as an independent candidate, joins a political party. So, all these are the grounds upon which a member will lose his seat.
A member
then, as regards being expelled, the Constitution says that if a political party expels its member, unless that member has decided not to challenge the expulsion, then the seat will be vacant. But if a member is expelled by a political party, and that member decides to challenge that expulsion in court, those days we used to rely on injunctions. Politicians would rush to court and get an injunction. But now this is by operation of the Constitution.
Which means you don't have to obtain an injunction.
No,
the moment you just file in a petition.
When you just challenge it in court,
then you
remain in office. Now, what the Constitution goes further to say that if after the court has heard the matter and have decided that the expulsion is justified, then such a member will lose the seat. If the court, after hearing the matter, decides that the expulsion is unlawful, then there are two options. Either that particular member will remain a member of a political party and retain the seat, since the expulsion would have been nullified, or there's an option, he may resign from that political party and retain the seat as an independent. What's the rationale here? The rationale is that if the party expelled this member, the assumption is that obviously there's no good relationship between them.
So the court can keep you in parliament by that clause?
Only if, by the subsequent clause, only if
they delay in making the judgment, you stay in parliament.
You stay in parliament
as a
until judgment.
member of parliament?
Yes, until judgment. But if there's no court matter, the moment any of these clauses chip in, then the seat will be vacant.
The only good point for the public in terms of curtailing by-elections is that once that happens, when you're expelled, you're not allowed to participate in the by-election.
Yes, because the idea also intends to show that if a person resigns from a political party, you cannot resign from a political party and hope to bounce back in the by-election. So if you make a cautious decision to leave the party which sponsored you for election to the National Assembly, be rest assured that you will not be able to participate.
For that life of that particular parliament.
For the life of that particular parliament. So if members of parliament should know that if they choose to resign, then, or they're expelled, then they won't participate in that particular one. So by implication, it means that members of parliament will be, if they want to remain MPs, they will have to make peace with their political parties.
We're also looking at the clause which talks about by-elections being held within 90 days, yes, but not within 180 days period that precedes a general election.
Yes, again, I think the aspect of 90 days has always been there. Every time a seat is declared vacant, election should be held within 90 days. But then the Constitution has now provided that such election should not be within the 180 days, should not be within 6 months from the date of the general election. So if we're going to have elections in August, 6 months before that, I think to come to about March or something. Yeah, by March, we should not have by-election. So basically, that's the principle. So the election should be held within 90 days, but then they should not be such that the period of holding that by-election goes into the 180 days before the general election.
So what is the rationale behind that?
Maybe the idea is that what's the purpose of electing someone? Maybe you'll just be in parliament for 2 months, or is it for a month, and then next parliament is even dissolved in any event. Because parliament will have to dissolve, is it 3 months before the election? So what's the purpose of electing someone and then parliament to be dissolved? So maybe it may just be a drain on the resources.
The resources of the nation. Now, there's another huge complaint on the grade 12 certificate qualification.
Yeah.
A lot of debate around that. What do you mean when you say an equivalent of a grade 12 certificate? ECZ has already confessed that, this, according to media reports, at least, they're saying this is a thorny issue.
Yeah, I think it's for ECZ or maybe the qualifications authority. They know what document. Of course, the grade 12 certificate is there, so it's easier. But what constitutes equivalent, I think that's a question for determination by, I don't know whether it's ECZ or maybe the qualifications authority. They are the ones who should know, because they're tasked with that responsibility to check what qualification is genuine, what qualification is equivalent to the other. In fact, I would maybe call upon the qualifications authority to give guidelines on what would be an equivalent of grade 12.
Do you see this as a major conflict point after the elections or during the filing in of nominations?
Personally, I don't think it will be. Because the Constitution says a minimum.
Is it GCE? Is it school certificate? Is it Cambridge?
Yeah, so all that is, what is equivalent to grade 12? I think it's a simple question for the electoral committee, I mean for the examination council, in my view. The examination council or the qualifications authority, they know what is equivalent to, even for instance, admission to ZIALE. It says a degree from University of Zambia or any other recognized university internationally. I don't think ZIALE has a problem to find that any other recognized university, they can do that. So in the same way, the issue of grade 12, I'm not too sure whether it's very difficult to find out what is equivalent to grade 12. But like I said, this is a matter which the qualifications authority or maybe even the ECZ should come forward and explain. ECZ as in examinations council.
Or do you think people should take this matter to court for interpretation?
Possibly, if, but again, yeah, there's no problem with that. But basically, that's the issue. It's supposed to be grade 12 or an equivalent. An equivalent, like you have said, what we call grade 12 certificate, for instance, it's not there in London, maybe. They have got another term for it. But then you know there's primary school, there's secondary school. When you finish secondary school, you get grade 12. Maybe in London, when they finish secondary school, what do they get? So to me, I think it's a question which can easily be resolved by the qualifications authority or indeed by the examinations council of Zambia.
And the complaint that this clause particularly is very discriminatory, considering that so many Zambians are illiterate.
Yeah, I don't know about the discrimination aspect, because everywhere when talking about qualifications, if you're going to talk about for someone to qualify to do anything, you are discriminating. You're implying that others won't qualify by the very nature of qualification. So the question really is maybe looking at what's obtaining on the ground. Do we have enough people, for instance, in all the constituencies, say for all the councils? Do we have enough people in rural areas to stand as councillors who have got that document? If they don't, again, like I said, these are the provisions which, upon seeing how it applies, people can actually come forward and then an amendment can be effected. The only issue is that I'm not too sure that can be done before the August elections on account of there's that provision which says that within the standing order in Parliament, to say Parliament may not amend its act within 6 months after it's passed. So unless, of course, Parliament regulates its own procedure, unless they change that, but
so they first have to suspend that standing order in order for them to go back and debate this grade 12 clause. Well, for now, the nation can be assured that we're going to the polls with the grade 12 clause.
Well, I don't think I'm able to give that. But as of now, like I said, it's possible for Parliament to regulate its own procedure and even to change something. So I don't think I'm in a position to assure. But as of now, that's what the Constitution says. And I believe that if there will be sufficient representations to the effect that there's need to change, an amendment can be effected. Like I said, there may be certain provisions which will be applying in the Zambian context for the first time. They may have worked somewhere else, but will be applying them in Zambia for the first time. So if there will be need for an amendment, that can be done for some time. But as of now, as the law is today, that requirement is there.
Now, coupled with this complaint about discrimination, it also comes back again when you talk of 1,000 threshold for presidential supporters. This opens the whole race and pushes the bar too far, too high for so many people. They're saying now you're limiting presidential election to people that can afford to buy supporters.
No. I think what this constitution is doing, even for requiring 50+1, 50%, at least for someone to be elected president, they need to get 50% of the votes, over 50% of the vote cast. What we are looking at there is legitimacy. If we will no longer have a president who have 20% of the vote. Any president we're going to have going forward will have to be a legitimate president in the sense that they would have at least the majority of the people who voted. So the idea there is legitimacy. If someone wants to stand for president, you cannot claim to have legitimacy if you can't raise 100 people in each province. Legitimacy means that you're widely accepted. So to me, I don't think it's a bar. It's a question of proving legitimacy. And if you notice, the Constitution again says that each political party shall not be regional. It must have representation across the country. So maybe all those are the points which enhance the aspect of legitimacy and political parties having presence everywhere.
Now, coupled with that, high fees by the ECZ, you're talking about 75,000 for a presidential candidate. Governance by the elite and the rich.
For presidential candidates, fortunately, there are no independent presidential candidates. We're talking about the party. For any person who wants to be president, they have to do so under a political party. And to talk about 75,000 too high for a political party, well, I don't know. But I believe that...
And probably 10,000 for a councillor?
Yeah, maybe...
For a mayor?
Because in those instances where we have independent candidates, maybe to some extent it may be too high, but representations can be made to the Electoral Commission, who came up with these fees. I'm sure they can maybe look at them.
Simple computation. Somebody has done some computation, and they're saying for a party to sponsor candidates from presidential level up to councillor level, they probably need to be 35 million kwacha rich, 35 billion unrebased. Isn't this too much?
Well, but if that party is going to contest the presidency, obviously their budget will have to be much more than that. But like I said, these are fees which the Electoral Commission came up with. I believe that with sufficient representation to the Electoral Commission, I'm told they met with the stakeholders, the political parties, is it yesterday or the day before yesterday? So it's dependent on the stakeholders, the political parties. If they're happy with the figure, I'm sure the Electoral Commission would not have, I mean, the position will be as is. If they're not happy, I believe the Electoral Commission will address that. Maybe possibly they will amend, but it depends on what the political parties will have to say. But by implication, 75,000 for, is it 75 or 35?
75,000 kwacha for a presidential candidate?
Yeah, if someone wants to be president and for a political party especially, not an individual, but a political party, 35,000 is not very high.
75,000.
Yeah. So to me, I think the political party can afford that. But if they can't, like I said, these are fees which the Electoral Commission came up with.
And they're probably not cast in the Constitution.
No, they're not in the Constitution, yeah. So they can easily approach the ECZ, and depending on the representations they'll make, I'm sure it will be addressed at that level.
Let me take you to the preamble of the Constitution, which says, which declares Zambia as a Christian nation, but at the same time upholds the country as a multi-ethnic, multiracial, multi-religious. Isn't this contradictory?
To me, it's not. It's merely saying that as a country, the primary religion is Christianity. And then it also, in the same breath, it says that while upholding a person's right to freedom of religion, among others. So, meaning that people in Zambia have a right to their own religion. And de facto, it being called a multi-religious state, it means that all religions are able to operate. But as a country, our primary religion, or our foremost religion, is Christianity. So I'm not too sure there's a contradiction in that.
Does it in any way say Christianity has more rights than the other?
No, because everyone is free to practice their own religion. So it's not like Christianity has a certain right. No. For instance, if I'm Christian, I practice Christianity. The other person is Muslim, he will practice Islam. They do what they do, I do what I do. So I don't think it's a contradiction. It just says that the governing, maybe the governing or primary religion is Christianity. I think that's what it means, basically.
More privileges for Christianity.
I don't know whether there's any. I think everyone is free to practice their own religion. So there will be no, my understanding is that no religion will be stopped. If someone is Hindu, they will practice that. If someone is Christian, they'll practice that. But as a country, we have given ourselves as a primary or maybe the foremost religion is Christianity. But everyone is free to practice whatever they have.
Let's look at political party funding. Article 64A speaks of establishment and management of a political party's fund to provide financial support to political parties with seats in the National Assembly. Yes. When does this law get into effect? Yeah,
because again, that's one of the laws which says that it shall be prescribed. If you go further down that same provision, you will find that there shall be an act of parliament which will prescribe what funding political parties will have, to what extent they have to account, and also some regulation on how where they get their money and so on and so forth. So I believe that also will come into effect upon there be an act of parliament. Now looking at the time between now and the elections, chances are that maybe
this law may not be for now.
May not be for now. It may be for after the next election.
What does this law mean, really, if you're going to interpret it? Does it mean if you get government funding, then the way you raise your money, the amount that you have to spend on elections is restricted? Will that depend on the act?
No. Of course, the money will be given to facilitate mostly the elections and mobilization and all. But quite obviously, like I said, there will be an act. Right now, I'll be speculating on what will be in the act, because the Constitution says that there shall be an act which will prescribe how the same issue will be addressed. So to say whether there will be restriction on how you spend the money.
It gives a bit of an indication when it says source of funding, when the law itself touches on source of funding.
Obviously, maybe there will be an issue if someone is receiving funding from, if a party is receiving funding from people with wrong motives, or maybe which will undermine the security of the state. Obviously, I would like to believe such will be the restrictions which will be in the act. But for now, I can't state what exactly will be the restriction. But one thing is clear is that there will be some funding for those political parties which will have seats in parliament. And then secondly, there will be some form of regulation. There will be some form of accountability. Political parties will have to account. Firstly, how they use the money which they will get from the state, and also how they are using the money from other sources. It will be necessary that people know where the funding is coming from.
Now, this same law has attracted a little bit of debate and concern, with some quarters saying, why should we fund political parties, which are almost like private clubs? Why should the state fund? Why should we use public money to fund political parties, which are very private institutions?
These are the issues. You recall that His Excellency, the President, before the passing of this constitutional amendment, for a long time, he has been saying, we have to debate the contents of this constitution. I mean, the draft constitution. But then people were just preoccupied in saying, let it be passed without debate. So it would have been better if all those issues were raised before the bill came into place. But then we have to move on. Like I said, let's see how this constitution, this amendment we have given ourselves will work out. If the people will be of a view that maybe why should we, like you're saying, why should we fund political parties? If they're going to if we're going to entrust them with the responsibility of managing the affairs of the country, surely they should be in a position maybe to raise their own funds. So if that's what the people will say, maybe, again, we'll talk about an amendment. But like I said...
If government did manage to remove certain clauses from the Constitution, and there's some of the clauses you could still have removed anyway, from the draft.
Yeah, so I'm saying that we needed to get a view from the people. The people have to... That's why I'm saying that the way this amendment was effected was in very difficult circumstances, because the moment we saw some areas which needed to be adjusted, if we attempted to do that, we're going to say, no, government is now doing away with what the people wanted. So the level of changes, like with respect to provincial assemblies, was very minimal. It was minimized. It was something where you are constrained to do that. But like I said, we have this document. Let's see how it's going to run. If the people feel like there's need to change, they'll have to.
You would rather it runs for some years?
Well, not necessarily for some years. Whenever it will be possible. Because again, it's not my views per se, but the views of the people of Zambia. If the people want a certain clause to continue in place, then so it shall be. If the people will say, well, this clause is not necessary, again, that will be the position. Look at the American Constitution, for instance. The American Constitution has been in existence from over 300 years, and there have several amendments. They amend the Fifth Amendment. It goes on and on. So I believe that as a country also, we'll continue perfecting it. We'll continue perfecting it.
Let's look at the referendum. Again, I'll refer to your role as Attorney General, Chief Advisor to government. You've allowed government to run through with this idea of having a referendum together with the elections. Isn't this a very complicated matter? Complicated event to handle? Two big events.
In fact, that was what ought to have been done, actually, was going to be the full constitution being subjected to a referendum together with the election. So what was done instead was to say, well, there are these certain clauses which are not so much in dispute. These ones, where we can amend them, let's amend them. And then those ones which we can't even deal with unless there's a referendum, let's subject them to a referendum. So to me, I don't see it as a complication. Of course, the only challenge which will be there is to ensure that we have got sufficient numbers in terms of people coming out to vote. Article 79 says we need at least 50% of people who are entitled to register to vote.
So do we need a census now?
Sorry?
There's a bit of contradiction. Some people are saying we need a population census before we can undertake the referendum. Do we need to undertake
right now,
that?
I'm not too sure when the last time a census was conducted. And I believe there are experts in that area in terms of census and so on and so forth. But the bottom line is that the Constitution says that all those who are entitled, because there are projections which are done, all those who are entitled to registered voters, at least we need 50%. I would like to believe the Central Statistical Office who can assist in that regard.
So this is a tricky adventure. You're going into an election and people's emotions will be very high. Even the judgment on the Constitution will be somehow not really very clear.
Yeah, I hope that government, the civil society organizations, they will come forward and actually carry out sensitization and public awareness programs to ensure that people know that besides the aspect of choosing leaders, they also have to deal with the issue of amending the Constitution in terms of the Bill of Rights and Article 79. So it's something which all of us should take an active interest in.
As we went down the interview, I want you to look at the issue of the dual citizenship. It's a clause that has been welcomed by many as that which will benefit Zambians, particularly people in the diaspora. They'll be motivated to come back and invest. What benefits, on the other side, what benefits do you lose when you decide to hold dual citizenship?
Actually, it's just an advantage to Zambians who are in diaspora, like you have stated. For instance, some of them have been outside there for a long time, and they've had to make a painful decision to decide whether to be a national of the country where they are or to be a Zambian citizen. And most of them, maybe due to circumstances, have opted to be nationals of that country. So what this clause talks about, it allows them to apply so that they can retain the Zambian citizenship. Of course, there are certain provisions that you cannot run for president if you have got dual citizenship. But then, ultimately, it's an advantage to Zambians who are out there to say they can always retain their Zambian citizenship while they maintain the citizenship outside. But again, there is no fear of foreigners getting Zambian citizenship. Because if a person is actually a foreigner, this clause, it doesn't help or improve any chances of that person becoming a Zambian. So
and in a hypothetical situation where the two countries in which I hold citizenship are at war, which one do I support?
Maybe that will be the individual.
Can I be charged with espionage?
I don't know, it will depend on the individual's choice of where they want to support, but I don't know, I can only speculate.
Well, it's really hypothetical. Now,
yes.
There's one other issue that has come up, a debate in the public media, in the media again, where people are saying the president doesn't have powers to dissolve parliament anymore.
Well, there is a provision in the Constitution which actually gives him such powers. There's a provision which says that should the president be of a view that Parliament, that is the National Assembly, is not performing its functions, is no longer in a position to perform its function, then he will first inform the public, then thereafter refer the matter to the Constitutional Court. If the Constitutional Court will agree with him, then they'll inform him to say, we agree with your position, and then the president will dissolve the National Assembly. So, to me, he has power to dissolve, but
now,
of course...
the provision which says Parliament will stand dissolved 90 days before a general election, does that take the powers away from him to dissolve Parliament, actually dissolve Parliament when in times of an election?
Yes, the aspect of dissolving prior to the election, that one is by operation of a law. By that 90 days, it has to happen. But after that, maybe 1 year after the general election, the president can choose to say, or at least before that 90 days, before we reach the 90 days, the president can choose to, if he's of a view that the National Assembly are not able to discharge their functions, he can initiate the process and then which can culminate into the dissolution. This is outside the dissolution which comes by operation of the law.
Mr. Kalaluka, thank you so much for your time.
Thank you very much.
You've been watching Sunday Interview, and our guest this evening was Mr. Likando Kalaluka, State Counsel, the Attorney General. Till next week at the same time, pleasant viewing.